Student Animal Legal Defense Fund chapter here, or we know it as the John Marshall Animal Law Society, and I want to thank you guys all for coming today. We have a really exciting speaker, but first, before we do that, as all of you know at school, but I don't know if everyone knows here, we have the winners of the Harvard Animal Law Closing Argument Competition here, and I just want to have them recognized. So if Shane and David could please stand up and we can give them a round of applause. So our speaker, Joyce, actually helped write the problem for the closing arguments competition, so that's really exciting. So I'm here to introduce Joyce Tischler. She's a co-founder of the American Legal Defense Fund and Animal Legal Defense Fund. And she's a California attorney and has helped shape the emerging field of animal law. She's handled some of the Animal Legal Defense Fund's biggest cases and earliest cases, including a lawsuit that halted the U.S. Navy's plan to kill 5,000 feral burros and a challenge to the U.S. Patent Office to allow patenting of genetically altered animals. So she's also tackled diverse topics such as enforcement of the Federal Animal Welfare Act, standing to sue, animal custody battles, the right to kill animals pursuant to will provisions. She's handled some landlord-tenant issues. And Joyce was the Animal Legal Defense Fund's executive director for 25 years, and she now serves as the general counsel and oversees their litigation program. So we are so excited to have her here today, and can you please give a round of applause for Joyce Tischler?
Do people have to leave by one to get back to class? Okay. Hi, I am thrilled to be here. It just occurred to me that some people may have to leave to get back to class at 1, so this speech is longer than that. So don't feel embarrassed if you need to leave. Can you hear me all right? Oh, good. Okay. I'd like to take you on a sentimental journey back in time to the beginning of animal law, when there were no animal law classes, no student chapters, no internships or externships or fellowships or jobs of any kind for lawyers or law students who were interested in protecting animals. All there was way back then was a blank piece of paper waiting to be written on. So who were those ancient mythical lawyers who conjured up those first fledgling lawsuits? What faraway lands did they come from? Through what invocation did they summon up this movement? And how did their mystical passion for animal rights affect their lives? It's lucky for you. I happen to know some of the answers to that, so I'd suggest you sit back, get comfortable, don't take notes. There will be no test on this. The first animal rights lawyer was a man named Henry Mark Holzer. He was a New York attorney. He specialized in constitutional, administrative, and appellate law, and he was a professor at Brooklyn Law School. He made a small donation to a group called Friends of Animals, and the president of Friends of Animals, a woman named Alice Harrington, invited him to dinner. He swears to me it was a small donation, but I guess at that point, at that point in time, you got invited to dinner. What caught his attention during their discussion at dinner was Harrington's description of the Federal Humane Methods of Livestock Slaughter Act of 1958. That act specified that in order for slaughter to be humane, the livestock must be rendered insensible to pain by a single blow or gunshot or an electrical, chemical, or other means that is rapid and effective before they were held up in the air, shackled, hoisted, thrown, and cast. But the act also authorized ritual slaughter, where the animal loses consciousness by, and I'm quoting from the act, simultaneous and instantaneous severance of the carotid artery by a sharp instrument. Basically, that's a knife cutting the throat. And additionally, the act exempted ritual slaughter from the terms of the act completely. Now, as traditionally carried out in ancient times, kosher slaughter was considered to be quite humane. The animal would be held on the ground, held still, his carotid artery would be slit, and quickly produced unconsciousness. However, modern American health laws precluded holding the animal on the ground. So the shackle and hoist method was developed. The animal would be chained by a rear leg, hoisted into the air, where his carotid artery was slit. Sometimes hips would dislocate, sometimes the terrified animal would struggle, the artery would not be cleanly cut, and it was often quite ghastly for everyone involved. Now, Holzer at this dinner had his constitutional law hat on, and he thought that the creation of an exemption to a federal law that provides special protections to the dietary preferences of a particular religious group violated the Establishment and Free Exercise Clause of the First Amendment, and he wanted to file a lawsuit to challenge this exemption. So he approached the board of directors of Friends of Animals, and they said, no, we really don't want to be involved because it may be perceived as anti-Semitic. Holzer, who is a Jewish atheist, said, I'm going to bring the case anyway, and I'm going to be the plaintiff. So he filed his lawsuit, and it received press coverage. And he received phone calls from about a half dozen animal welfare organizations. And he thought, great, they'll be co-plaintiffs with me. And each time he asked them to join, he described the lawsuit, the goal. And each time he asked them, they said, oh, no, we don't want to go anywhere near there. Well, then he got a call from a woman named Helen Jones. Now, Jones was one of the founders of the Humane Society of the United States, HSUS. And she had served as its director of educational activities. The first major federal project that HSUS worked on was the drafting of the Humane Methods of Livestock Slaughter Act. And Jones had worked hard for its passage. But soon after they introduced the bill's author, Hubert Humphrey, was approached by a number of leaders of the Jewish community, and they wanted him to create an exemption for their religious slaughter practice. Now, remember that this was the mid to late 1950s. It was a little over a decade after World War II and the Holocaust. The Jewish leaders reminded Congress that one of the first laws passed by the Nazis was a ban on kosher slaughter. And HSUS and Hubert Humphrey believed that it would be politically naive, and would doom the bill if they didn't make the compromise. So they did. And the bill got passed. It was the first major legislation setting humane standards for slaughter in this country. Helen Jones, who had fought very hard for the bill, was sorely angry about the exemption, and she had opposed that compromise. And for the next several years, she was looking for a lawyer who would challenge it. And so when she heard about Holzer's lawsuit, she called him immediately, or almost immediately, and she opened the conversation by congratulating Holzer on his lawsuit. And Holzer thought, oh God, here comes another one of these patronizing animal activists, and said, look, lady, if all you want is to pat me on the back, but you're too scared to join in. And she stopped him and said, no, I want to join in. I'd like to be a plaintiff, and I'll help you find other plaintiffs. And that was the beginning of a very lengthy relationship between the two of them. To my knowledge, this is the first true animal rights, animal protection lawsuit. It grew out of a tension between those who sought to protect farmed animals and those who sought to protect a long-time religious practice of ritual or kosher slaughter. Holzer dismissed his initial lawsuit and filed Jones versus Butts, which, for those of you taking animal law, is in the casebook. With Jones's help, he now found 15 plaintiffs. They had Jewish, non-Jewish, and atheist vegetarians. They had Jewish, non-Jewish, and atheist meat eaters. They had consumers. They had taxpayers. Holzer was trying to choose a range of plaintiffs so that somebody in that group was going to have standing. They alleged that the Act's provisions relating to ritual slaughter were unconstitutional as written and as applied. The Southern District of New York granted the defendants' motion for summary judgment, holding that while they did have standing, the Humane Slaughter Act did not violate the Establishment Clause. And the court said, quote, Congress considered ample and persuasive evidence to the effect that the Jewish ritual method of slaughter and the handling preparatory to such slaughter was a humane method. Congress did not create a religious preference, nor did it create an exemption to any general rule. The court cannot be asked to choose among methods of slaughter or pre-slaughter and handling of livestock, or to decide which is humane and which is not. We do not sit as a super legislature to weigh the wisdom of the legislation. So what Holzer and Jones experienced in this first lawsuit was something that has plagued animal lawyers ever since. Human interests trump the interests of animals in many, if not most, of the cases that we're dealing with. They were challenging the chain and shackle method, which I've witnessed and which is quite inhumane. So why did they lose? Because human beings were sitting on that court, and they were not going to overturn either the will of Congress or the will of a political minority on such a politically sensitive issue. It just wasn't going to happen. They weren't going to attack the dietary preference of a minority that had been almost annihilated less than 15 years earlier. In fact, the court bent over backwards to find for the defendants. The legal reasoning in this decision is shoddy and it's strained, and that's a criticism that applies to many of the cases that we deal with. On the bright side, if there is any, this was Holzer's entry into the world of animal rights, and he was open to learning all that he could about the abuse and exploitation of other species. He didn't merely represent the clients, he wasn't just the hired gun, he joined the cause, consciously extending the concept of public interest law to the plight of animals. And he is still associated with ISAR, the group that Helen Jones founded, today. Now, 3,000 miles away, in 1978, two animal rights attorneys met on the West Coast in San Francisco. I was one, and the other person was a guy named Larry Kesnick, who was a partner with a large law firm in the city. And we wondered whether there was anybody else out there like us. So we placed an ad in our local legal newspaper, and 6 more people showed up at the Fund for Animals office in San Francisco, and we started meeting every month and teaching ourselves about the federal laws and the California laws that related to animals. In April of 1979, Larry Kesnick received a short note from Hank Holzer, who introduced himself and asked to be put on our mailing list, which we didn't really have a mailing list, but we put him on. Meanwhile, just about the same time in 1979 in Detroit, Michigan, there was a law professor named David Favor, and he was starting to think about these issues. In 79, he published an article, a law review article called Wildlife Rights, the Ever-Widening Circle. And that article marked an important intellectual and emotional shift for David. He shifted from the traditional environmental law perspective of viewing animals as a group or as a species, and he started to think about them as individuals. If you think about that for a moment, that is a major shift for an environmentalist. Holzer read the article and contacted David Favor. So you're starting to see who the nexus is here. Back on the West Coast in Los Angeles in May of 1979 was a very busy year. The U.S. Navy was getting ready to shoot about 4,000 feral goats on a tiny island off the coast of California, a place called San Clemente. The Fund for Animals, which was headed by Cleveland Amory, hired an attorney named Marcelle Philpott Bryant and asked her to sue in U.S. District Court in the Central District. Marcelle used the National Environmental Policy Act, NEPA, claiming that the Navy, the federal agency, had failed to prepare an environmental impact statement, and further that the method of killing was going to violate the California anti-cruelty law. She got a temporary restraining order, and then later a preliminary injunction, and defeated the Navy's plan to kill these goats. Now, the interesting thing about that lawsuit is that Marcelle was using NEPA to protect animals who were not endangered, and they were not even native to the area. She was using the law in a way that environmentalists had not intended, would not support, and this was providing early evidence, if anybody was listening, that there was a new breed of lawyer starting to pop up. Soon after that case, Marcelle met Larry and me, and following our lead, she organized a Los Angeles chapter of our little group, which we then called Attorneys for Animal Rights. And fortuitously, she gave us a set of the pleadings from the goat case, because in March of 1981, we faced an emergency. On a Thursday afternoon, Larry had received a call from a group called the Animal Protection Institute in Sacramento, and they told him that they had gotten a call from someone who wanted to remain anonymous from the Naval Weapons Testing Center out in China Lake, the Mojave Desert in Southern California. The Navy had shot and killed about 600 burros the weekend before. They were planning to go out again on Saturday and shoot another 500, and they were going to keep up the shooting until they had killed about 5,000 burros. Why? Well, because the burros were getting on the runway where their planes were taking off and landing, and at night a burro is hard to see, and they were coming up there for the water and the warmth of the runway, but they could down a plane. Serious problem. I'll be honest with you, I was born and raised in New York City, and I know what a burro is. There are 5 of them. I wasn't sure why the Navy was planning to attack the Bronx, but to be honest, I didn't know what a burro was. Could be a donkey, could be a weird-looking horse. What I knew is that if I didn't get my ass in gear, 500 of them were going to be dead in 2 days, and we had less than 24 hours to get to court. I later learned that burros are not native to the Mojave Desert. They were brought in by the charcoalers and the gold miners, and then when they didn't need them anymore, they just left them there. Burros are incredibly hardy. They've survived the intense heat of the daytime, the intense cold at night, and they've proliferated. Environmentalists don't like them. They eat endangered plants. They would just as soon get rid of them by any method. But we felt that the Navy had to come up with something better than just shooting them. So, we found this out on a Thursday afternoon. I ran home that evening from my full-time job, and I sat down to start working on the case. I had, 16 hours to get to court. But I had Marcel's pleadings from the GOAT case, also against the Navy, and I was going to bring a NEPA case. And I had a manual typewriter at my house. The reason I put this up is that David Favor heard me giving this speech, and he said, "Joyce, they don't know what you're talking about when you refer to a manual typewriter." So here it is. So I spent all Thursday night. Marcel and I talked. We agreed that I'd represent the Animal Protection Institute. I'd file in the Eastern District. She would represent the Fund for Animals, file in the Central District. Whoever got a TRO first, woohoo, and then we'd join our cases later. It was a basic NEPA lawsuit once again, failure to prepare an environmental impact statement. One of the problems was I'd just been out of law school for 3.5 years. I'd never been in a federal courtroom. I'd never done a NEPA case. I didn't know how difficult it was to get a TRO, probably better off that I didn't. Pulled an all-nighter, flew to Fresno the next morning, filed my pleadings, made my argument before the judge, and the Navy made their argument, and amazingly, the judge granted the temporary restraining order. I called Marcel, and we combined our cases into one. After we got the TRO, the Navy did draft and publish a draft environmental impact statement. As you would imagine, it said that the preferred course of action was shooting the burros. Very, very deep analysis. We attacked the EIS, the Navy defended it, and we spent the next 8 months doing whatever we could, frankly, to keep those burros alive. Finally, we went to a hearing on the preliminary injunction, and the judge told us to go into a room and reach a settlement, which we did. The settlement agreement was that the Fund for Animals agreed to remove all burros within a 275 square mile radius. The Navy agreed to reimburse the fund $50 per burro and release all rights and interests in those burros, and as a result, not one more burro bit the dust, which was great. Now, the case didn't establish any rights for animals, but it did accomplish several things. One, it saved the lives of several thousand burros. Two, it was one of the earlier signals that while environmentalists might not utilize NEPA to halt the slaughter of non-endangered, non-native species, animal rights attorneys would. Third, it fostered the move toward a professional collaboration between two of the few identifiable animal rights lawyers who were around at that time. And finally, it resulted in creating funding for the first full-time animal rights lawyer to work, and that was me. Within a few months after the TRO came out, the president of the Animal Protection Institute called me, asked if we could have dinner with his attorney. I said sure, and at dinner they asked me what they could do for me. And I'm no rocket scientist, but I was smart enough to know that you don't get asked that question too often in life. And I told him about this dream of working full-time for this organization and doing full-time litigation. They gave us a grant of $6,000, which kept us going for 6 months, and I left the law firm and became the movement's first full-time staff attorney. Our first annual budget was $12,000, and that was enough to get us started. Our second annual budget was $12,000. Well, we were on the right road, and we knew it. At about this time, in Boston, there was a very scrappy young lawyer named Steve Wise, and he had just read Animal Liberation, and he thought that Singer made a pretty compelling argument. So he took on his first animal law case, a vet malpractice case, and he kept taking those cases. And because those cases were unusual, he started being invited onto radio talk shows to talk about his cases and to talk about animal rights. And he thought he was the only one out there doing this at that point. Further down on the East Coast, about a month before I left the law firm, there was a college student in Maryland. His name was Alex Pacheco, and he decided to take a volunteer position at a place called the Institute for Behavioral Research in Tacoma Park, Maryland. Now, IBR was doing stroke research, and they were severing nerves in the limbs of monkeys in order to simulate a stroke. Pacheco and a woman named Ingrid Newkirk had a year earlier started a grassroots group called People for the Ethical Treatment of Animals, now known as PETA. And Pacheco wanted to observe research firsthand. What he found was more than he expected. He found pretty gross, quite gross, shocking abuse and neglect. Self-mutilation, chewing off of fingers, monkeys who had bandages that had not been changed in months. They had open wounds, they had sores. They were living, the feces in their cages was coming through the bottom of the cage. It had not been cleaned in so long. Their food was inedible and spoiled. There was no vet care. It was a hellhole. He brought this information to the local police, who came in, raided IBR, and seized 17 monkeys. They became known as the Silver Spring monkeys. Now, a lot's been written about this case and about PETA and Alex and Ingrid, but what I'd like to talk to you about is something that's less well known. The gentleman who prosecuted the case, and his name is Roger Galvin. The case was getting a lot of attention, and the heat was on. So the Montgomery County State's Attorney's Office assigned the pick of the litter to prosecute and to handle the trial. Now, Galvin was originally from Chicago. He described himself as a blissfully ignorant meat and potatoes kind of guy, and he prosecuted the most violent criminals of felonies. He was moving up the ladder, and when his boss assigned him to a mere misdemeanor involving a bunch of monkeys, he asked, what'd I do wrong? But epiphany struck when, as part of his due diligence, as part of his research, he asked Ingrid Newkirk to take him to where the monkeys were. They had been seized and they were removed from the lab. And so she took him, and they went, and she had brought a bunch of grapes and other things to feed them. And Roger went to the lab, and he went up to the cage of the only rhesus macaque, whose name was Sarah. And he put his fingers through the mesh wire of the cage to give her a grape. And he said, she grabbed onto my finger, but it wasn't in an aggressive way. It was more in a dependent way. And I looked at her hand, and it was like a miniature of my own hand. And that was the moment that I realized that I had a sense of responsibility for these animals and their future, more than I'd ever felt in any criminal trial I'd been involved in. And when they went back, he said, I began to notice that they had personalities. They were not just animals. And I realized that I was going to have to think about these animals and their situation more deeply. Early on, it was clear to him that the key to winning the case was proving to the jury that the standard of care had been violated. If a dog owner beats the dog, clearly that's cruelty. But jurors had never before been faced with what the standard of care is for a group of monkeys in a research laboratory. Now, Roger knew that he was going to have to establish what the standard of care was, and then he was going to have to find experts who would testify that the standard of care had not been met. he didn't think inedible food and being forced to live in their own feces was going to work. He thought the key was the veterinary care, the lack of veterinary care. He was right. Taub was found guilty by a jury of failure to provide necessary veterinary care for 6 of the 17 monkeys. On appeal, Taub was found guilty of one charge of failure to provide veterinary care for 1 of the monkeys. But then the tide turned. The Maryland Court of Appeals granted cert and reversed the conviction, claiming that the state anti-cruelty law, quote, simply is inapplicable to Dr. Taub and the laboratory, because Taub was conducting research pursuant to a federal program. The court looked at the legislative history of the state anti-cruelty law and said, quote, it can be readily seen that the legislature has consistently been concerned with the punishment of actions causing unnecessary or unjustifiable pain or suffering. Now, the pain caused in research is purely incidental and unavoidable. This is the only case in U.S. history in which an animal researcher was convicted, at least at the trial court level, of cruelty to animals as a result of the conditions in which the animals were kept. But at the appellate level, it shows us once again a legal system that's grappling with a highly controversial issue, the use of animals in research. Ultimately, they took the easy, if intellectually dishonest, way out of holding a wrongdoer responsible for his actions. For Roger Galvin, though, it was part of a significant change both professionally and personally. As a result of the case and all of the books and articles that he read, he became a vegan. He joined our board of directors. He ultimately left the state's attorney's office and formed one of the first, if not the first, animal rights law firms, Galvin, Stanley, and Hazard. It no longer exists today, but it paved the way for firms to come later. So as you can see, there were pockets of interest and activity. Detroit, D.C., Los Angeles, San Francisco. There was a woman named Jolene Marion who started a group in New York. But what we needed was something or someone to bring us all together. And that was Holzer. He was the visionary. He was the one who could see that the whole could be greater than the sum of the parts. And he created 2 primary vehicles to do this. He developed a publication called the Animal Rights Law Reporter, and that was published from 1980 to 1983. It contained a variety of cases and information and a bulletin board, and it was wonderful. That's how we all began to see that there were others in the country who were doing this work. Equally important, in 1981, he held a conference. It drew approximately 60 people, half of whom were lawyers and law students. It was like coming out of the fog and seeing the other members of civilization for the first time. And I know that's a feeling that a lot of you would have had when you first meet other animal rights activists or students. That's where I met Steve Wise, David Faber, Bill Reppy, who currently teaches at Duke. Ingrid and Alex were there talking about the Silver Spring Monkeys case. Marcel was there. Larry Kesenick came. Peter Lovenheim, who was working for HSUS, and several other people who were at the core of animal rights work. Before we got to the conference, Holzer called Larry and me and told us to form a national board of directors and occupy the field. I thought the guy was crazy. What field? You have to have a fair number of people to develop a field. We couldn't even form a basketball team. But we followed his advice. We announced that we were going national, which seems so silly, and we invited all to join. And our national board included Steve Wise, David Faber, Roger Galvin, Marcel Philpott Bryant, Sarah Lewick, who was working with Steve in Boston, Jolene Marion, who I'd known since college and started a group in New York. And we then had chapters forming in Boston, Los Angeles, D.C., and New York. It was a small group, and it stayed a very small group for a number of years. We supported each other emotionally and intellectually. We had very little money. We were spread all over the country. We talked a lot by phone, just about daily. We would get together for long weekends. We'd bring our sacks and we'd camp out at someone's house, and we'd plan together and we'd dream together. And we worked on a broad spectrum of issues and all possible species: hunting, trapping, animals in labs, companion animals, farmed animals. And some of you may recognize some of the people in this standing up over there, well, Nancy Shestak, Steve Wise, a lot younger than you've seen him, Gary Francione next to him, Ken Ross, Larry Silver, who was with Earth Justice, Peter Levenheim, Nancy Ober, Sarah Lewick, me above Marcel, Roger, Jolene Marion, and a young David Faber. One of the earliest cases that we took was Aldiff versus Pravimi veal. We were tackling the problem of calves in intensive confinement. You know, healthy calves are playful and bouncy and joyful. They're like puppies. But the male calves don't provide milk, so they have no use, or the dairy industry has no use for them. Well, the Pravimi Corporation created a use, put them in intensive confinement so that they develop fat, not muscle. Feed them an iron-deficient body so that their flesh is white, not the normal red. And you can sell them as a specialty product, milk-fed veal. Now, the Boston chapter, Sarah and Steve and the other folks there, decided to challenge this method of raising formula-fed veal calves. First, they sought injunctive relief to bar Pravimi from selling the meat of special-fed veal calves because of the total confinement of the calves. They said that violated the anti-cruelty laws of the state of Massachusetts, and that the meat was tainted and unhealthy because it lacked iron. Second, they sought injunctive relief requiring any seller of veal to display on the package a truthful explanation of how the calves were raised so that the consumer would know what he or she is buying. Well, the case was lost. The court said there is a federal scheme regarding the packaging of meat, and you're trying to do an end run around the cruelty laws. Well, there were some cases in which we did come out ahead. I'll give you another bit of veal calf before I get to them. There was a series of California cases in which we utilized the California Environmental Quality Act, which is our mini NEPA in our state. We stopped mountain lion hunting between 1987 and 89. We stopped 2 black bear archery seasons, 1 bear hunting season. We forced the Department of Fish and Game to prepare environmental analyses for all hunting seasons. They had never done that before. And we got a favorable decision on a Fish and Game Code section which oddly mandates that the Fish and Game Commission has to consider the welfare of individual animals when they set hunting seasons. As the field expanded, the number of lawsuits grew. And there were lawsuits to recover damages when companion animals are killed or injured, lawsuits challenging deer hunts and river otter hunts, and the removal of wild horses, and the list goes on and on and on. What have we learned in all the years? And in an hour, it's hard to share that all with you, but one of the things that has been a takeaway for me is a visual image that David Faber developed in one of his more recent articles. You know, Steve Wise has the image of a great impenetrable wall. David said, well, maybe it's not a huge high wall. Maybe it's a river. The river's the barrier, and the humans are on one side, and they all have rights, and the animals are on the other side, and they don't have rights. But a river has shallow, narrow parts. Why don't we look for the shallow, narrow parts of the river in order to incrementally build interests and ultimately rights? And that really resonates with me. Today, our litigation focus is on developing civil lawsuits with cutting-edge legal theories where the recovery goes directly to the animal. And you're probably saying to yourselves, what does that mean? Get them out of harm's way is one of the primary ways that we do that. And I'll give you an example. We've been looking both federally and state by state to see if there are laws on the books already that we can use. And in North Carolina, we found a law, Section 19A, that provides a civil remedy for the protection and humane treatment of animals in addition to the criminal laws. Now, one of the primary problems we have with the criminal anti-cruelty statutes is something happens, abuse, cruelty. The prosecutor won't prosecute. What do? Nothing. There is nothing you can do. Totally within the discretion of the prosecutor not to prosecute. But in North Carolina, we can enjoin cruelty civilly, and we can get possession of the animal. It's all written in that law, and standing is broad. So we gathered evidence. At first we were looking at zoos and roadside zoos because the North Carolina cruelty law specifically exempts farming, research, entertainment, sports, veterinarians, and a few other things. But we couldn't get enough evidence on the zoos, so we started looking elsewhere, and we started talking to activists, and we found that there was a situation in Sanford that had existed for many years. Barbara and Robert Woodley had a puppy mill, which had turned into a hoarder-collector situation. They had 500 dogs, kept in conditions that were so bad, it's not an overstatement to call it a concentration camp for dogs. Many of the dogs had cataracts, had fuzzy vision because they were living in their own urine and the ammonia was damaging their eyes. Some of them were blind. Most of the dogs, in fact almost all of them, had rotted teeth from, again, living in their own excrement. A few of the dachshunds actually had fractured jaws because the teeth rotting was so significant. There were untreated cancers. There were broken bones that had never been set. Have you ever had a toothache? Imagine what it would be like for your entire mouth to be aching day after day, year after year. Well, before our lawsuit was filed, Mrs. Woodley got nervous, and she had some local breeders come out and clean out the garage. They took out 170 dogs who were in the kind of crates you use for cats and small dogs. They were piled 4 and 5 high, and those dogs were never let out of those crates. They were living in their own excrement. Some of them were dead. We filed our complaint in late 2004, and we took it to a hearing on preliminary injunction. The judge actually left the bench and went to the Woodley's farm, came back, issued a preliminary injunction. Wouldn't allow us to take the dogs off the premises unless they were in dire condition, which we were able to do for about 100 dogs. Otherwise, our vets were coming in daily and giving medical attention for the first time to the rest of the dogs still there. Now, at that point, the prosecutor, who had been unwilling to act, was willing to file criminal charges, 12 criminal charges on the animals in the absolutely worst condition, and we provided all of our evidence to them. In fact, we basically did a lot to make that case happen. At this point, in the next few months, the chief judge took the case. The criminal and the civil, moved to trial in tandem. Trial was held in March of 2005. The Woodleys were found guilty of cruelty, and the court also issued a permanent injunction. All rights and ownership of the animals was forfeited to ALDF. We could remove the animals as soon as the order was signed. But there was also a temporary order until the appellate process was resolved. We had custody, but we didn't have ownership. And then all claims for monetary relief were denied. So basically, it was fabulous. We won the case. We utilized 19A. We got no money to care for the animals, and we got custody, not ownership. So what were we supposed to do? Here we were, a litigation group based in California, with 330 sick, unsocialized dogs in North Carolina. Well, you rely on the kindness of strangers. A local business person donated the use of a building that had not been used in 20 years. There it was, our shelter. Local vets donated over $100,000 of free medical care. The Hills Corporation donated 4 pallets of food. PetSmart donated crates and towels and bedding. Volunteers from the community came in and worked with the animals, cleaned them. They had to be washed repeatedly when they first came in just to get the urine out, socialized them, sat with them, fed them. And that was one dog coming from Woodley's to the shelter. When they first came, some of them defecated. They'd never been handled by humans before. They were so afraid of humans that they defecated when they were touched. The Woodleys gave us the wonderful gift of appealing this case up to the North Carolina Supreme Court level, and we won at every level. So not only did we get the dogs, we got good law in North Carolina. And there's another one of the dogs just arriving at the shelter. All of the dogs have been adopted. There's Casper and his new home, to good homes, including one kind of ugly, homely little Boston Terrier who came back to California with me. Now, since we got such good law from the Supreme Court, we've been able to go back to North Carolina several times and have been able to seize large numbers of animals using this law. We would love to see it be drafted and introduced in other states. So, where are we today? Well, there's a field now. Today there are 132 law student chapters, including the chapter here. there are 101 animal law classes, including the class here, which we're pleased is happening. 13 state and regional bar sections, 4 scholarly law review journals. In 2008, working with Lewis and Clark, we opened the Animal Law Center. The Center for Animal Law Studies, I just blew the name, which is offering not only an animal law class, but clinical opportunities, fellowships, a visiting scholar program, and other extensive educational opportunities that I didn't dream of. Maybe Holzer did, but I certainly didn't dream of back in 1979. The legal scholarship in the field of animal law has been incredibly high, led by Stephen Wise, who has written books and that's not Steve, I know. It's a family member, but who's written books, better hairdo, written books and law review articles developing the basis for animal rights theory. He has reached out to eminent scholars such as Cass Sunstein and Martha Nussbaum, who were here in Chicago, who went on to edit a book called Animal Rights, Current Debates, and New Directions, which is an exploration of both sides of the issue. It's a wonderful book. Professor Lawrence Tribe, leading constitutional law expert at Harvard, has written and lectured on animal rights for animals. In a 2001 Law Review article, he stated, "I certainly haven't solved the problem of how best to persuade others to share one's deep intuition that chimps and dolphins and dogs and cats are infinitely precious, like ourselves, and that it is unjust, that it is obscene and evil to treat them as things that anyone can really own." And there's a new generation of lawyers cropping up all across the U.S., working in small firms and in large firms and in city agencies and federal agencies, staffing nonprofit organizations and carrying on the tradition of creative lawyering to speak for those who cannot speak for themselves. 30 years isn't a very long time in the development of a field of the law. We're only beginning to explore the legal theories that could be argued to provide greater protections and ultimately rights for all animals. And I think that our most exciting and progressive litigation is yet to come. I'd like to leave you with a quote from one of my favorite poets, Wendell Berry, who said, "We clasp the hands of those that go before us and the hands of those who come after us." Those of us lucky enough to be at the birth of the animal law movement still carry the vision of a world in which the lives and interests of animals are respected within the legal system, a world in which animals are not exploited, not terrorized, not tortured or controlled to serve frivolous or greedy human purposes. And we look to you, the new generation of animal lawyers, to write the next chapter of our story, to share our vision and walk down the road with us towards a far more just and compassionate society. I want to thank you for listening, and feel free to contact me at ALDF, and I'll be happy to take any questions for those of you who don't have to run off. And there's the love of my life. Anybody? Did I put you? Yes, thank you. If one is going to eat animals, the best thing one can do is raise them yourselves. You're going to pay a lot more attention to them than a corporate farm does by a mile. So the move away from family farms has been one of the worst things that's happened to farmed animals, other than being eaten at all. Anyone else? Yes?
Do you see any other federal or state statutes that could be used in the way that NEPA was used by you guys?
No. No, I think one of the failings of the early animal welfare movement was the lack of passage of statutes, and even more so citizen suit provisions. We spent years trying to litigate under the Federal Animal Welfare Act, and it just has been an absolute nightmare because no citizen standing. So I think that the wave of the future, there is going to be some passage of some good federal legislation, but a lot of us are looking at the state level And as you can see from what HSUS has been focusing on, initiatives to try to clean up farmed animal abuse at the state level. And also with the change in the federal judiciary, when I was going to law school in the 70s, we still had a relatively liberal federal judiciary. We don't anymore. And while we may be able to do some animal welfare cases at the federal level, challenging anything to do with research or factory farming is going to be very tough. Yes?
Is there anything similar to your organization or organizations in Canada?
No, not yet. We're just starting to see some involvement by Canadian attorneys. It's actually been slow, and I think now we have, 7 chapters?
There.
Yeah.
Where?
I'll find out for you.
Yeah, it might be McGill, but I'm not sure. Yeah, and it's starting to spread to other countries as well. There's a group now in Australia called Voiceless, and we are their role model. They're not doing litigation, but they're doing a lot of educational work there. Yes?
Have you done any work regarding the breed banning legislation laws in certain cities?
We filed an amicus curiae brief in Denver challenging breed bans. Breed bans, same old wine, brand new bottle. I mean, I don't know about you, but when I was a kid, the aggressive breed du jour were Doberman Pinschers, and then it became German Shepherds, and then, I don't know, Rottweilers, and then, it just goes on and on and on. Now it's pit bulls. Breed bans are not going to work. Ban the people who would fight with those dogs. Fight those dogs. Yes?
Do you think the legal rate case has brought a lot of disease animal abuse that maybe hadn't?
Absolutely, yeah. When I was in law school, when I wrote my law review article on legal rights for animals, I remember being in touch with a Los Angeles investigator who had risked his life to investigate dog fighting, and it was prosecuted, and then they all got off with a $250 fine and got the dogs back. And that's how things were for decades. So, I mean, Michael Vick is the best thing to come along in decades for those of us who wanted the world to know about dog fighting. I mean, I don't want to thank the guy, obviously, but it's been amazing how that has brought about just an incredible media rush to learn more about dog fighting. And I've spoken with so many people who never would have thought about it before. So yeah, it's been great. So I think we are done with questions, and people probably need to move on. If you need to reach me, jtischler@aldf.org, or just call our phone and say hi and ask any questions that you'd like to. Thank you for coming.